All right, welcome back. As you know, we often at this program try to cover evergreen issues as well as emerging issues in civil justice, and sometimes there are evergreen issues that constantly have emerging issues. And so we're delighted to once again revisit the issue of scientific methodology, admissibility of expert testimony, and the judicial gatekeeping role. And with that, we have the steward of our panel this time around is Judge Katherine Crytzer, who is on the U.S. District Court for the Eastern District of Tennessee. We are also very honored that Judge Crytzer is a graduate of Scalia Law School and also one of our newest board members on the Judicial Education Program Advisory Board. So with that, I turn it over to the excellent stewardship of Judge Crytzer.
Don, thank you for that kind introduction, and thank you to the Law and Economics Center for having our panel here today. As you've already heard, this is one of those evergreen issues in the law, whether you're working as a state court judge, a federal judge, or something in between. We're always serving in this gatekeeping function. As you've likely already seen from your materials, we have a panel full of experts in their own right. In my gatekeeping role, I'm going to keep our introductions short so that we have time for a robust discussion, for question and answer at the end. We start with Emily Acosta down at the end. Emily is a nationally respected trial attorney at the Wagstaff law firm, where she dedicates her practice to litigating complex personal injury, wrongful death, and products liability cases across the country. Then we have Kelly Brilleaux. She is an experienced products liability litigator, focusing her practice on both individual and complex mass tort litigation. Then we have Nathan Finch, a member at Motley Rice, LLC, with over 30 years of experience representing people who were hurt or killed by corporations. And certainly last but not least, we have Katherine Nolan, who is an associate at Hollingsworth, LLP. Her practice includes complex civil and commercial litigation, including serial litigation, multi-district litigation, class action litigation, and single site suits. Kat, can you get us started by laying some of the tone, setting out the regime? What are we looking at in recent developments?
Absolutely. Thank you for the introduction. And I just first want to say it's an honor to be here and a privilege to be speaking with these distinguished panelists. Just to give you an overview of what I'll be talking about, my remarks today will provide you a history of Rule 702, the developments over time, the reasons for the recent amendment, and I will go over some implications for state court judges. And I'll give you a few practical tips when you're evaluating Rule 702 motions when one hits your desk, what you might look for and how you'll evaluate things. So everybody's favorite, let me start with a little bit of history. Prior to 1975, expert testimony in federal courts was governed by the common law. The common law rule granted judges broad discretion in admitting expert testimony if it was beyond the knowledge of your average layperson. Then in 1975, Federal Rule of Evidence, Rule 702, was adopted, and it formalized the rule that an expert may testify if their scientific, technical, or other specialized knowledge would assist the trier of fact. Then in 1993, the Supreme Court decided the landmark case of Daubert versus Merrill Dow Pharmaceuticals, instructing judges to act as gatekeepers. From that point on, they were required to evaluate reliability and relevance before it got to the jury. Daubert, followed by Joyner and Kumho-Tyre, focused on factors such as testability, peer review, error rates, and general acceptance, and confirmed the judge's gatekeeping duty applies to all expert testimony, not just scientific. These three decisions, commonly referred to as the Daubert Trilogy, were codified in the 2000 amendment of Federal Rule 702. This is right here on the screen behind me, without the edits, which reflect the 2023 amendment changes. Generally, the rule provided that expert testimony is admissible if it will help the trier of fact and is based on sufficient facts or data, uses reliable principles and methods, and reflects a reliable application of those methods to the case. So what happened? Why was the 2023 amendment deemed necessary? Professor Daniel J. Capra, the advisory committee's reporter that drafted both the 2000 amendment and the 2023 version of Rule 702, said the wording of the rule wasn't flawed. The issue was that some wayward courts were not faithfully applying it. In other words, the rule's text said all the right things, but not all judges were consistently following the letter and intent of the text. The advisory committee made clear its purpose in amending Rule 702 again was not to rewrite the rule, but to restore and clarify how it should have been applied all along. So how bad was the problem? The advisory committee studied federal rulings and found that many courts were misapplying Rule 702. Some courts declared issues like the sufficiency of an expert's basis or the reliability of the methodology's application were merely questions of weight for the jury, not an admissibility issue. Others declared that there was a presumption in favor of admissibility of testimony. These approaches conflicted with the actual text of Rule 702 and Rule 104A. Under Rule 104A, the court must decide all preliminary admissibility questions, and the proponent of the evidence bears the burden of demonstrating reliability by a preponderance of the evidence. When courts were treating the reliability factors as matters for the jury, they were effectively relaxing the standard that the rules imposed. A 2020 survey of over 1,000 federal trial court decisions found that 65% of them failed to even mention the preponderance of evidence standard. And many districts had judges split on whether or not to even apply it. There was a related concern about experts overstating their conclusions beyond what their methods could support. The issue was highlighted in a forensic science debate. For instance, in a 2016 report by the President's Council of Advisors on Science and Technology, they pointed out that in fields like DNA analysis, fingerprints, ballistics, and bite marks, experts sometimes testified with unwarranted certainty. Some claimed 100% accuracy in identification matching, despite the lack of empirical support for those absolute conclusions. Overstatements like that can be very misleading to the jury. Given these concerns, an amendment to the rule was proposed. After an extensive notice and comment period where over 500 public comments were submitted on the proposed change, reflecting viewpoints from plaintiffs' counsel, defendants' counsel, academics, scientists, and judges, and following approval by the Judicial Conference and the Supreme Court, the amendment took effect on December 1st, 2023. Two key changes were made. First, the amendment makes explicit what has always been implicit. The proponent of the expert bears the burden of establishing admissibility by a preponderance of the evidence. This is not a new requirement. It codifies the standard applied since 2000, but the amendment removes any doubt that the judge must decide admissibility, and the burden does not shift simply because the opposing party raises an objection. Second, the amendment fine-tuned subdivision D of Rule 702 to curb the overstatements they were concerned about. It is not enough for an expert to purport to apply a method correctly. The resulting opinion itself must logically follow from a sound application of the method. For instance, a forensic examiner who has a reliable methodology to compare fingerprints should not testify that a match is established 100% for certain if the method is known to have any error rate. Similarly, experts shouldn't claim a causal inference that their data cannot validly justify. The committee note specifically cautions that in both civil and criminal cases, forensic experts should avoid assertions of absolute or 100% certainty if the methodology is subjective and thus potentially subject to error. So some of you may be state court judges and are wondering why this matters to you, because this is all about the federal rule. Well, the answer is that many state rules track the federal rule, word for word or in close substance, and many others incorporate the 2000 amendments framework. Because the advisory committee notes were clear that the 2023 amendment was to clarify the rule and not change it, the 2023 amended language is a natural interpretive guide for states with similar wording to the 2000 rule. Several states have updated their rules or have the amendment process underway. But even if your jurisdiction hasn't adopted the 2023 wording, the clarifications can be persuasive authority on what the reliability and burden provisions have always meant. So now for some practical tips. Treat each element distinctly, A through D. You could encourage counsel to brief the Rule 702 issues in terms of the rule's elements, rather than a generic reference to Daubert. This helps focus the analysis on the rule's actual requirements. If the showing is borderline, request targeted supplementation. If a hearing will meaningfully help, hold a focused one. This doesn't mean that a full Daubert hearing is necessary for every case, but it does mean that if reliability is questioned, as a judge, you should not be admitting the testimony without comment. The best practice is to issue a short explanation, either in writing or orally, addressing each of the 4 factors when those are disputed. This creates a clear record and helps demonstrate that the court has applied the correct standard. Consider updating your bench checklists and orders regarding expert evidence and reflect the 2023 language. When you're making rulings on admissibility, citing the new Rule 702 text or the advisory committee notes can reinforce the decision's foundation. Lastly, a word on balance. You will likely hear at some point, or you probably have already heard fairly, that gatekeeping must not become a merits mini-trial or an obstacle to legitimate claims and defenses, especially where science is evolving. The preponderance standard respects that balance. It does not demand perfection or unanimity in the literature. It asks whether it is more likely than not that the opinion is grounded in sufficient facts and a reliably applied method. A well-developed record, including reports, depositions, and if helpful, a focused hearing, enables that decision. Your role as gatekeepers is neither to pick winners nor to resolve scientific debates, but to ensure the jury hears opinions that rest on a sufficiently reliable foundation, stated no more strongly than the data and the methods allow. That is faithful to the rule's text, respectful of the jury's role, and most importantly, workable from the bench. Thank you, and I look forward to the discussion.
Nate, can you tell us a bit about the actual impact of these amendments?
From my perspective, I don't think they've had that much of an impact at all, at least in the way that I approach a Daubert hearing. I think there's case law, which I'll briefly gloss over, but just to give you, and like the other panelists, I am grateful to be here. This is about the 15th time I've been asked to speak by the George Mason Law School. It's a wonderful opportunity. How many of you are trial judges? I am a trial lawyer. I have tried over 25 jury cases to verdict, most of those for asbestos victims, about 8 or 9 of them for cigarette smokers against the tobacco industry, and then a handful of other kinds of cases. I've also tried 20 different cases to bench trials in front of federal district court judges, often in the context of a huge asbestos bankruptcy disputes. I've done a bunch of arbitrations, but I've also, at this point in my career, have done about 60 Daubert hearings, both hearings with witnesses and hearings where I'm making the arguments. And this is a picture of what a Daubert hearing should be about. That is Judge Eduardo Brilleaux, who was a U.S. District Court for the Eastern District of Pennsylvania, who oversaw some Daubert hearings in the asbestos MDL 15 years ago, and I had the great privilege of trying a case in front of him. He's a wonderful judge. He came here from Cuba and very much believed in the right of jury trials and why jurors are very good at understanding scientific evidence, or any kind of evidence really, if the lawyers do their job. The touchstone of all this is the Supreme Court's Kumho Tire decision, which is when you're looking at a Daubert hearing, does the expert in the courtroom apply the same standards and the same methodology, because Daubert is all about methodology, as the same kind of expert would in the real world? Meaning, if a doctor diagnoses someone with nicotine addiction in their private practice, when they do that and they come into court and said, yes, this person is addicted to nicotine, did they apply the same standards in the courtroom that they did when they're practicing medicine out in the real world? Ms. Nolan did a terrific job of summarizing the changes to Rule 702. There has been some post-amendment case law that deals with that. There was a case out of the Federal Circuit in 2025 this year called Echo Factor versus Google that reversed the trial court's admission of damages expert testimony, in part relying on the changes to the rules, but I think they would have probably come out the same way before the amendments. There's case law that says, really the whole point of this rule is to make sure that judges, you have the job to be the gatekeeper. You can't just say, well, it's all a question of weight for the jury. And then finally, there's a case out of Oklahoma, the Northern District of Oklahoma, that says that pre-2023 case law can still be relevant to a Daubert inquiry. It didn't change the landscape. So why do I say that it hasn't changed things that much? It's because from my perspective, a Daubert hearing is an opportunity for me to educate my trial judge and to try the case to him or her before I try it to a jury. But for the expense and cost and the logistical aggravation of getting your experts to a courtroom, I want to go into a Daubert hearing showing not only that my experts have reliable science on their side, but also they are right and the defense experts are wrong. And I've had the great pleasure to do asbestos cases for many, many years and cigarette cases, and the fact is my experts are right and the defense experts are wrong. And so I use it as an opportunity to educate the judge because I've done a lot of bench trials too, and judges may be smarter than your average juror, but they're not smarter than the smartest juror in a panel. And just because they are sitting on the bench doesn't necessarily mean that they understand things more than a jury might. But I like to use it, even though the case law says it's not a merits inquiry, I like to put on the best evidence possible through my experts or if I'm explaining what they're going to say. And I embrace that we the plaintiff has the burden of proof by the preponderance of the evidence to show that the science is reliable and supports the expert's opinion. And then I've got some ideas for how I analyze and how maybe a court should analyze whether the expert reflects a reliable application of the principles and methods. And so when I am arguing Daubert motions, and for purposes of trial court judges, I think there's a difference between something that has been in the literature or in the science for 40 or 50 or 60 years and is very well established and very, very well regarded versus something that is new and is just coming down the pike yesterday. How many of you believe that smoking cigarettes causes lung cancer? That, believe it or not, I've had argued Daubert motions directed at my experts in cigarette cases on that point. That is not something that any judge has spent a huge amount of time on because that's so well established by the medical and scientific community that that's not something that, and something like that, you don't need to spend as much time as is something that's brand new like artificial intelligence. The second way I argue this, and I think courts should look at it, is how would this play out in the real world? If a doctor comes in and is going to testify to X in the courtroom, does he or she apply the same methodology when they reach the same result in the real world if they were practicing medicine or practicing engineering or practicing cell biology or whatever it is they're doing? And then the question of how deep in the weeds do I need to go and how deep in the weeds should the judges go, I think depends on how well established the subject matter or the expert field is. I'm prepared to go as deep into the weeds whenever I walk into a courtroom as any judge or any juror wants me to go. But from your perspective as a busy trial judge, maybe you don't need to go as deep into the weeds on the question of does cigarette smoking cause lung cancer as you would to the most new genetic defense. Some of the issues that come up repeatedly in toxic tort cases are epidemiology. We all became amateur epidemiologists during COVID when we learned about how disease progresses through populations. How many of you heard doctors say that secondhand smoke causes lung cancer? The Surgeon General of the United States says that. And there's a misconception that in order to show causation, you have to have a doubling of the risk, 2 times the excess risk. And in fact, the Surgeon General of the United States determined that secondhand smoke causes lung cancer based on a whole bunch of very well-designed epidemiology studies where the relative risk was more like 1.2 or 1.4. Another issue that pops up from time to time is, do you need to have product-specific epidemiology? Do you need to have, in a smoking case, epidemiology specific to Camels versus Winstons versus Marlboros versus Chesterfields, when it's the same toxins in each of those brands of cigarettes? In an asbestos context, you need to have a separate epidemiology study for each of the 3,000 different types of products exist in the world. And my argument, and I've always been successful in asbestos cases, is that no, you don't. If you know that rat poison is a poison, whether you put it in a cookie or a cupcake or a wedding cake or anything else, it's a poison. So you don't need a product-specific epidemiology study. Now, here is an area where Daubert is going to, you're really going to have to dive into the weeds, at least in some areas, which is genetics. Everybody knows the concept of genetics, meaning how many people know somebody who smoked 2 packs of cigarettes a day for 50 years and never got lung cancer? That's genetics. Every cancer is either genetically caused or it is a combination of your environmental exposure to toxins plus the genetics. And so in the context of a Daubert hearing, if somebody is a smoker and they get lung cancer, it's well established that the cigarette smoking was a cause of the lung cancer. And so you can say that. I don't need to I don't need to dive into the weeds on that. But if somebody comes in and says, oh, there is this genetic marker that shows that the lung cancer this 60-pack-year smoker got was caused by genetics and not lung cancer, you may need to dive into the weeds a lot deeper on that. And I often argue that, the genetics defense ultimately boils down to is eggshell plaintiff, meaning if something is well established as a carcinogen, you don't need to know the exact genetic way it causes the disease. But if somebody's trying to say that even though the person was exposed to the carcinogen for 50 years and they got sick, they shouldn't, you can point to the genetics and not the carcinogen. That's where you'd have to, in my view, you'd have to pay more attention to and focus more on the weeds of what's going on with the genetics. Like I said, the more well-established something is, I think the less you need to spend. Asbestos has been known to be hazardous for actually 100 years now. It's been known to cause mesothelioma, a fatal cancer, since the early 60s. Every scientific agency in the world has said that every asbestos variety causes mesothelioma, that one day of exposure can cause mesothelioma. In 1964, there was a big conference in New York that said that. And, Daubert challenges are routinely denied in that. And so I don't think you have to spend a lot of time if something is so well established. I mean, most of the arguments that the defendants make in asbestos cases are thought up, they're not thought up, but they're used by this guy. Russia is the largest exporter of asbestos in the world, and they use the same arguments that defendants make in courtrooms to try to sell asbestos to third world countries. If it's brand new, though, then you really got to dive into the weeds. And AI is sort of coming down the pike for everyone. And I would argue that you're going to be faced with Daubert challenges involving AI very, very soon, because it's going to become the standard of care in medicine. It's going to become the standard of care in many other fields where human beings are going to be relying on AI to help them do their jobs. And the question is, if an expert comes in and testifies about the failure of a doctor to meet the standard of care and the doctor relied on AI, whether that testimony is admissible or not, you're going to have to understand and dive into something that's completely new. So I'm going to stop. Like I said before, I don't think putting on a black robe makes you any smarter than 6 or 7 or 12 jurors. And I would just urge you in Daubert challenges to think about why we have the 7th Amendment to the U.S. Constitution, why we have the 6th Amendment that preserve jury trial rights. And if it's a close call and you're waver in favor of letting a jury decide. Thank you.
Kelly, we definitely heard from the plaintiff's perspective there. Are things any different from the defense perspective?
They're quite different, Judge. Thank you for asking. Hi, everyone. My name is Kelly Brilleaux. I practice now in Dallas, Texas. I actually recently moved from New Orleans.
And just to give you a little bit of context about my personal experience, I primarily defend manufacturers in the pharmaceutical and medical device space. I've been fortunate enough to work on a few different multi-district litigations, MDL, and this is, Rule 702 has such a big impact in these cases. But I've also worked on other smaller cases at my prior firm before I moved to Barnes & Thornburg, which is where I am now. I worked on some trucking cases, so it really has application beyond just this pharma and medical device, but it's obviously very impactful in this context. So with that in mind, I want to kind of respond to a few things that Mr. Finch said. First of all, you will hear this from many defense lawyers if you haven't already, but we are on a mission. Don't say Daubert. Don't say it. It's not the standard anymore. It's Rule 702. Don't say Daubert. So that is, you will hear this from defense lawyers. I think that there is a place for the case law that Daubert is a part of, but the focus on the 2023 amendments to Rule 702 really focuses the judge's attention to the language of Rule 702, and it has really made it expressly clear now what the expectation is. And so before, I think it was, prior to the 2023 amendments, I think it was very typical to see reliance on the actual language of Daubert, and that was, the standard at the time. And now, the 2023 amendment expressly requires the proponent of the expert testimony, as Mr. Finch very kindly conceded, to demonstrate that more likely than not, the 4 admissibility requirements are met under Rule 702. And that means that the expert's opinion must reflect a reliable application of those principles and methods that the judge has already determined to be reliable. So not just is the expert qualified, is the information reliable, but does the opinion come out of an analysis that's consistent with the methodology that they're purporting to offer? And I think that that is what is really important here. There are some new cases that have come out since the 2023 amendments, and I don't know, I certainly as a defense lawyer never thought I would get up on a stage in front of a room of judges and tell you to read a Ninth Circuit opinion, but here we are. There is a recent case called Engilis, Engilis, out of the Ninth Circuit. It was a roundup case, and it's a really well-written opinion. I would encourage you all to read it because it really does break down why the Ninth Circuit has decided that the analysis is different after the Rule 702 amendments of 2023. And what it really focuses on is there was a conception prior to the amendments that there was a liberal thrust to Rule 702. And what the proponents of that position believed was that we're going to kind of defer and err on the side of letting scientific evidence in, and we're going to let the jury decide how much weight they're willing to give it. And what the 2023 amendments intended to do, and what the Engilis opinion does such a good job of setting forth, is no, the judge is the gatekeeper. This is not going to the weight of the evidence. It's instead going to whether this evidence should even be heard by the jury. So I think previously and prior to the amendments, there was an idea that we should kind of err on the side of letting it in, letting the jurors hear it, letting the jurors do the hard work. And I think from the defense perspective, we are calling on the judges, you are the gatekeeper, and that is the emphasis of all of this. You're the gatekeeper, and look at what is presented here very, very carefully. Not only does this expert have qualifications, is this expert's method reliable, but is the opinion consistent with that? And Engilis was a really interesting case. again, would encourage you to read it because it does a very good job of kind of breaking down the pre- and post-amendment reasoning. But in Inglis, there was an expert oncologist, so this is Roundup, and the injury for Roundup was blood cancer, right, leukemia. And the oncology expert had issued a report that said that more likely than not that the plaintiff's cancer was caused by Roundup, and that he had ruled out all of these other potential causes. I've always called that differential diagnosis, but apparently, according to Inglis, and I agree after reading this, the better term is differential etiology when you're talking about causation from a legal standpoint. And so what the court said in Inglis was this expert said that he ruled in all of these things and that he ruled out all of these things, but he actually didn't, because there was evidence that the plaintiff at some point was obese and had a BMI over a certain level, and obesity has been tied to the same medical condition that was caused here. And in that case, the expert said, well, I relied on the plaintiff fact sheet, and the plaintiff fact sheet said negative for obesity. But on cross-examination, it was very clear that the expert did not know one way or another if the plaintiff was obese, did not know what the plaintiff's weight was. And then after that, another expert then relied on the oncologist, and his opinion was struck too. And so what I think is really fascinating about this is it kind of almost requires another step from the court, which is not only is the methodology reliable, is the expert qualified, but did the opinion actually go through every step of that methodology that it was supposed to? And I think that that is what is very powerful about that case, and would encourage you to read it. From a defense perspective, and kind of to counter what Mr. Finch was explaining, especially in this mass tort space, which is what I'm familiar with, we are sometimes dealing with thousands and thousands of plaintiffs that are claiming the exact same injury. And as you all know, as judges, in any tort case, a plaintiff cannot proceed without causation. At what point that happens is going to differ, correct? And one thing that I think is really critical from a defense perspective especially is the idea that the law should not lead science. Novel theories should not be the basis of litigation. I actually really liked Mr. Finch's example. I'm not going to make any concessions about what causes anything, but there's a big difference between a smoking MDL and, for example, an MDL that deals with whether acetaminophen causes ADHD or autism in babies. That we're dealing with two very different things. And I think that it's important to look at how far along these theories are established when you're weighing the evidence that's appropriate to go to the jury. And another example, too, I worked on the Xarelto MDL, and without speaking anything on behalf of my client or anything like that, it was the Xarelto MDL was about a blood thinner that caused bleeding. We're not disputing general causation that blood thinners cause bleeding. They do. That's what they're supposed to do. And so I think the difference when you are looking at, okay, when should I be looking at this causation issue at some point in the litigation, if general causation is not disputed, it might be a little bit later. But if the general causation is disputed, can this thing cause the injury that's being claimed? It is going to be better to look at that causation aspect, which includes the scientific and the expert evidence, earlier on in the litigation, and to hold off on some of the liability issues, such as the marketing, the economics, the money. And obviously, specific causation then is, did this product cause this person's injury? So if you have an MDL where you have thousands of cases, it's going to be beneficial for everyone to get those cases where you know those plaintiffs who are not going to be able to establish causation can get out ahead. And so some ways that can happen is so if general and specific causation are going to be tested together, which is sometimes the case, you can do a phased kind of causation discovery in your cases. And I think that even outside the MDL context, this can be very significant when there is a real disputed scientific issue that is, that's at issue in the litigation. And I've seen this in trucking accidents too. I mean, in trucking cases, there are a lot of times experts that are opining on things like traumatic brain injuries. And that is a huge part of the claim, because if you have a case that arises out of a car accident, a slow-moving car accident, that ends up being a wrongful death case because of a brain injury, it's going to be very efficient for you to address the issue of, okay, are we actually going to be arguing about this issue? And if you are, then I think it's significant to really focus on getting those claims that the plaintiff is not going to be able to prove out before it goes to the jury and before you're deciding things such as liability. So with that, I am going to pass it over to Ms. Acosta for some more of the plaintiff's perspective. I'm sure she's going to disagree with some of the things I said.
Emily, round us out here. What additional cases, strategies do we need to be familiar with?
Yeah, sure. So I guess I should start. Thank you so much for the invitation. I'm very happy to be with you all. And I'm exceedingly pleased that so many of you are trial judges because like Nate and like Kelly, I'm a trial lawyer. And so, what I spend most of my time doing is trying to figure out how to package really complex ideas in a way that's accessible and understandable. And so I guess to kind of zoom out a little bit, one of the things, as someone that handles only catastrophic injury cases, and the only thing that really changes the context is the product that's caused this catastrophic injury for so many people, a pesticide, a drug, or a medical device. The thing about representing injured people is before they get injured, they had this whole life, right? And so a lot of times people, they might have a family history of cancer, they might have a family history of heart disease, they may have had orthopedic surgeries, and I'll use Roundup because it's a litigation I'm very familiar with, and it'll require me to teach you very little in order to understand the examples. But, in the context of Roundup, for example, being a man or being of a particular age might also be something that you would call a risk factor for non-Hodgkin's lymphoma, which is the kind of blood cancer that Roundup causes. I sort of view these, and we've sort of talked, I think, both in the context of more general causation, and I think a lot of times when people think about Daubert, they think about sort of defending a Daubert challenge for their expert. What I'm sort of going to share with you is kind of our strategy for the Roundup litigation in particular, which now that the litigation is a little more mature, involves a lot of what I would call affirmative Daubert strategies. And not just, we have many of the experts that we have at our law firm, we have had since the beginning. They are, preeminent experts in the field. They have been giving the opinions they give us in court for decades prior to, joining the litigation. But, the thing that we think of a lot is, okay, these people have all these sort of pre-existing, conditions that don't necessarily relate to the cause of their non-Hodgkin's lymphoma. But I think, again, in the context of juries, it's sort of difficult to hear that someone has a family history of cancer and not put that out of your mind, even if all the expert testimony is going to say that actually isn't a real risk factor. That's not attributable in terms of a cause. And so we sort of are very aggressive in terms of affirmative Dauberts and use them as a way to, exclude evidence on a reliability basis so that later we can exclude it on a relevance basis at sort of like an MIL type stage. So I guess to kind of get you up to speed on the Roundup litigation and what might be important things when you're evaluating what might have caused a particular person's non-Hodgkin's lymphoma. So we mentioned age, we mentioned gender. I have deposed, and our law firm has deposed, I would say, several dozens of, oncologists that work for Monsanto, that work for Bayer, are retained experts. We have yet to encounter a single one that says that age is a causative factor or says that gender is a causative factor. Yet everyone that writes a report will say, oh, but this person's, this age and this person's this gender. And part of that, I think, is a function of epidemiology. When you look at, asbestos, for example, men are far more likely to work in jobs that might expose them to asbestos. Similarly, when you look at gardeners or agricultural workers, they're, predominantly more men than women. And so as you sample those populations to understand what relationship working with pesticides might have with later developing subsequent conditions, you'll get more men than you will women. Does that mean that, gender causes it? No, of course not. And that's what all of Bayer's experts will tell you too. And so those are sort of two risk factors that are not causative. There are others that, again, are kind of hard to hear, though all the science sort of suggests that they're not risk factors. Things like obesity. A BMI, the Inglis case was mentioned, so I'll address it, but a BMI under 30 does not have a significant risk, increased risk. There is a moderate risk from 25 to 30 on a BMI. It's something like 10 to 20% increased risk. Roundup, by contrast, will increase your risk of developing non-Hodgkin's lymphoma by 288%. And that's after only 13 days of exposure in your life. By contrast, you can't smoke 13 cigarettes and increase your risk that way, right? And, you could probably have 13 days of asbestos exposure and increase your risk, but that gives you a sense of, the toxicity that we're talking about. The other that's sort of hard to hear is smoking. Smoking, when you get to, say, over age 45, most people that are, 45 plus now will have some history of smoking. The literature, and again, we've daubered a lot of Bayer and Monsanto experts on this topic. I had someone tell me just the other day that the evidence supporting a link between non-Hodgkin's lymphoma and smoking is weak. The amount of smoking you need to do and the kind of cancer you could get, there's a very particular, it's for women and it's for follicular lymphoma, which is a, very small subtype of, kind of all of the non-Hodgkin's lymphoma cases. So unless you're in that bucket, that you're a woman and you got follicular lymphoma and you smoked enough that under the literature that's sufficient, you really shouldn't be talking about smoking because it's not a risk factor that's relevant for that population. Similarly, there's kind of other things like, heart disease, for example, or things that sort of sound like bad conditions or sound like, oh, maybe this is an unhealthy person generally. And, the thing that we do very aggressively is we, heavily discover all these cases. We do depositions with all of their experts that, really address all of the risk factors that we think are non-starters, things that are truly irrelevant in the sense of how do we discover what it is that caused this person's non-Hodgkin's lymphoma. And, you would sort of be surprised, and I kind of am continually surprised at the number of times that you look at a report and it lists, 6, 7 risk factors for a person, but when you actually start talking with the expert at deposition and, say, well, what literature are you relying on? Isn't it true that, this is, the exposure we have in this case is lower than what was observed in literature. It's lower than, what you're relying on. you really are able to knock out quite a few of those. And then in terms of the motions we're filing to exclude, very sort of specific cause type things. I think once you get to, more mature torts versus sort of this, tip of the spear type stuff where general causation is a little more disputed, we, tend to focus then a lot more on specific cause, attacking very specific things that do not, do not present a legal cause or even a medical cause for a person's injuries, and then, later use sort of those victories to kind of leverage our way into MILs and things like that. I guess the other thing that I will sort of address generally is that, like Nate, I see Dauberts as an opportunity to sort of educate, judges and particularly, in the sense that as a litigator, I will spend, probably 2, maybe even more time working on a project, and a judge will spend, not nearly that much, right? They have other, you all have other responsibilities, you have other cases you're working on, right? And so, I think as advocates, part of our job is to, figure out a way to package this information, distill it, and make sure not only that we're sort of giving you good science, but also that we're, helping to kind of dispel some of the myths, some of the misstatements, some of the misunderstandings about science. And, Nate kind of mentioned a couple of them that I had down, relative risk not being high enough. That's not true for a number of, a doubling of the risk is in my opinion, something that, doesn't really follow science. And so I think in that sense is inappropriate. There's also, I think, in the way that Daubert challenges for a while, you could sort of wave at, well, that's weight, that's admissibility, it goes to credibility, so we don't need to worry about it. I think confounding is sort of a similar thing, that defendants often wave at confounding as if that's a way to discount every single study. And indeed, in epidemiology, you will never get a perfect study because it's not a drug trial. It's not controlled. You're following people around, they're living their lives, and you're trying to figure out if there are similar patterns. And so of course, it's also the only way ethically that you can study dangerous stuff, right? So, you can't just give people asbestos and see how long it takes for them to get sick, right? But you can give them,
There was a doctor in Germany who did that.
Right, yeah. And
His name was Mengele. He did it to Jewish prisoners.
and not ethical, right?
No.
But, so I think those are kind of a couple, the dose makes the poison is a nice soundbite, but it doesn't really recognize what modern toxicology recognizes, which is that there aren't necessarily always linear dose-response relationships. Sometimes low doses are bad, and sometimes, let's see. Yeah, there's also, sort of the myth that low dose equals low effect. That's not always true, and that's, again, as toxicology evolves, our sort of understanding as lawyers, and I think the ability of you to bring in more modern, science into a courtroom needs to also kind of evolve with these trends as well. The other one that I do think is important to address, only because Johnson & Johnson was raised, but, there is a notion that negative studies outweigh positive association and positive studies. I think that would be all well and good if we didn't have manufactured science in these cases. I'm currently working on a case now where we really can't believe there isn't manufactured science in the space, because I think as people that do this work, you're really used to that being one of the first lines of defense. But there are, a litany of companies that are hired by pharmaceutical conglomerates mostly, but also, the chemical industry is certainly guilty of this. But, there is a litany of manufactured science that is put out there specifically for the purpose of countering legitimate science and undermining legitimate science. And so, I think the notion that null or industry-funded studies kind of counter, studies that are showing positive association is something to sort of keep in mind. And I think for purposes of, is this reliable, is it not reliable, to, you know, look at particular studies and credit particular studies more than others, that's something important to kind of keep in mind, particularly as judges.
Thank you, Emily. We've certainly got a diverse set of experience and viewpoints here on this panel. Is there anyone who would briefly like to respond to what any of the other panelists offered?
I have a few responses.
Please go.
So, Mr. Finch, one interesting thing you mentioned was the development of AI and how that's going to appear in your courtrooms. Just a tip, you know, I don't know how familiar you are with AI, but if you do encounter one of these cases, things that you can be asking are, how was the model trained? What data was it trained on? One of the things that AI has been criticized for is coming up with inaccurate data because what the input was inaccurate. Junk in, junk out. So you also want to know what the actual command was, what was the directive, what was the question asked of the model, because that also impacts, you know, what were the guidelines it was given. And then were the sources cited? Were they checked? Were they cited? Were they accurate? Was the interpretation of the AI model correct based on what it was using? And then I think we'll get to this a little bit later, but I would like to talk about the echo factor case.
If there's no one else that would respond, Kat, go ahead.
Okay. So I don't necessarily agree that things haven't changed that much with Rule 702 and the recent amendment. I mean, there have been cases out of the 4th, 5th, and 7th Circuit that have, you know, said that they made a mistake or that they're overruling their own case law. They're specifically citing the amended rules. And I did actually write an amicus for the echo factor v. Google case on behalf, or in favor of Google's position. And that one was the U.S. Court of Appeals Federal Circuit case, and it was a rehearing en banc, and they reversed their own prior decision. They reversed the panel, too. In that case, they did specifically cite the amended rule, and so echo factors expert was using an appropriate methodology. There was nothing wrong with comparable licenses. In that case, it was a patent litigation, and the echo factor expert took agreements, several agreements that were the result of settlements, and they were lump sum agreements, and from that extracted a per unit rate that he said was a fair rate per unit, a per unit license rate. But those agreements that he based it on specifically said that this is a lump sum agreement, and there's no statement in here that says that it has any correlation to a per unit rate. That was in the settlement agreements. So in addition to that, the echo factor expert said, well, he's very experienced, very renowned, and ipsy dixit, like I said so, I'm experienced and this is fair because I said so. And the appellate court said that's not a proper methodology. You can't take things that specifically say they're not related and then go ahead and apply them. Well, so the methodology itself was fine, but it was how he applied it to the facts in that case. So that was a pretty important decision and one that was highly anticipated, and I think, it is guidance that things are changing. And in terms of citing, Mr. Finch also mentioned citing old cases and that it's fine. Yes and no, sometimes, right? Because there were 65% of courts that were misapplying the rule, so there was a percentage that was applying it correctly. But when you need to be careful because the amended rule did effectively overrule a lot of prior case law, but it's not going to be flagged as overruled because you can't tell without reading the judgment, specifically determining, did they go through the factors? Was there an analysis, a Rule 702 analysis, or was the decision just, it's admitted because it's probable, right? Do they follow the preponderance of evidence standard? So you do have to be very careful for cases before 2023, and make sure that they are not applying a more lenient standard.
My sense from reviewing the case law is, at least in the federal courts, there are a number of circuits who haven't weighed in on this issue yet. There are some that have, which Kat mentioned, and some that haven't. It's a potentially troubling area for a district court judge who might be handed a brief in a circuit where these issues haven't been addressed yet. You want to be mindful of the changes and how they may or may not impact the results in your particular case. At this point, we've got some time for questions. We don't have anyone lined up yet. Our first brave soul. We'll start here.
Thank you very much for this discussion, just fascinating. I'd like to hear from you regarding the interplay between subdivision C and subdivision D, where subdivision C talks about whether it's the product of reliable methods and principles, and D is the application of those reliable principles and methods. So if you have a product, aren't you assuming that it's been applied? How can you have one without the other? And when you're making your findings, how do you differentiate as a judge between those two subdivisions?
What would our practitioners like to see in this space?
I think the way I would look at it is the testimony the product of reliable principles. And for example, it's a reliable principle that differential diagnosis is a reliable way to come to a diagnosis. Does this person have nicotine addiction? Differential etiology is a reliable process for ruling in something as causative or ruling out. There's 60 years of medical science that shows that asbestos causes mesothelioma, and there's almost as long medical science shows that smoking cigarettes has nothing to do with mesothelioma. So I always file a Daubert motion if no defense expert really even comes in and tries to argue that anymore. So a causation analysis, differential etiology is the product. And then the next step is, did the expert do what he or she, did they follow the differential diagnosis or differential etiology process? And in the case of the Roundup, for example, if the expert says, I followed differential etiology and I ruled out X factor, whether it's obesity or whatever, because of X, Y, Z, and it turns out that they didn't do that, they didn't do what they said they did, or that they were wrong about some underlying fact, then they shouldn't be allowed to testify to that. So it's like, is the methodology sound science? And then that's C. And then D is, did they actually apply the methodology in a reliable fashion in coming to the opinion that they gave or they're going to give in the case? That's how I think about it, but I'm just a trial lawyer from Crozet, Virginia, so I'm not sure I know the right answer.
It's also about the methodology.
How do you have a product without application of those reliable principles and methods? I understand if we think C is, do they describe the reliable principles and methods? And then go to D, did they apply them? That would make sense to me, but this C, focusing on the product, the testimony being the product of these principles, you must have applied those principles to get the product. So
Sure, it's how the methodology, between C and D, it's how the methodology was used here. So the methodology was fine, like in the echo factor case. The methodology technically was fine. It's used in many patent cases, comparing different licenses, different agreements, coming up with a per unit rate. However, in that case, it was not reliable because it didn't make sense. It wasn't relevant. The agreements themselves excluded a per unit rate and said, we're not saying it is fair. So you can come up with a product that was the result of a known and a valid methodology, but if it doesn't make sense or if it goes beyond what the data can support, that's what D is trying to contain.
I would definitely agree with that. The way I think about it is, because it's the use of the word product, right? Because that makes it sound like, well, that's what we're looking at. But I think my interpretation, and again, this is just me, but my interpretation of it is this is what the expert is saying he or she is going to do. This is the methodology I followed to reach my conclusion. And then D is the expert's opinion, what the expert is actually concluding. And did they do everything in C to get to D? That's how I see it.
In a way that's logical and follows.
Yeah, and I mean, I was just going to add, I think there's a long string of cases that talk about sort of fit and like, do the opinions kind of fit the facts of this case? And I think that, although we're on a don't say Daubert quest, I think that line of cases is very helpful in terms of, understanding you need to not only have kind of, in broad strokes, something that happened that was, generally accepted in the community based in sound science, but also it has to, really fit the facts of the case. It has to be relevant to what it is that we're talking about with respect to this specific trial, this specific lawsuit.
Please.
This question speaks almost directly to the issue about the methodology as well. You had mentioned that the risk factors, you do not include, for instance, age or gender, that they're not causative factors, obesity, for instance, and smoking and heart disease. What I did not hear you mention as one that's not excluded, my question then becomes, is it included? And that is issues concerning race and also urban environment. And if they are included, are they included then by way of age, gender? Do those then become factors that you do consider? You had spoken also to the issue of genetics versus the carcinogen. So when you factor in those racial issues and also urban environmental issues, do you then change the methodology?
Yeah, so I think the answer is the way that I approach these cases, I think the right way to approach them is to look at the science and say, okay, how should we be screening, from my perspective, how should we be screening these cases? And also once we get to a litigation standpoint, like how should we be, attacking things that maybe don't matter, right? Because essentially I represent clients that probably don't have a perfectly across the board clean bill of health, and they are filing lawsuits about their health, right? And so that's kind of fundamentally the really big challenge that I face kind of in and out, right? For Roundup, things like having an Ashkenazi Jewish heritage, so like that, is probably race. Things like urban environment, in the context of Roundup don't matter very much, but again, that's from the epidemiology. In other settings or other products, I think you could sort of imagine how things like either race or, where someone lives could be either a direct sort of cause, or it could be sort of an approximation for something else, right? So, I think you have to look very carefully. I mean, part of what, at least internally, our strategy for this is, we're talking to our experts about like, is this legit? Is this legit? And, figuring out, okay, here's these 26 things in this report that don't have to do with cause, we should move on them. Eventually you do it enough that you're like, okay, I don't have to call him this time on this one, but I need to ask about something else. So I think you have to sort of lead with the science and where that is, but a lot of these things I think can either be real causes or approximations, but I'm just a lawyer. You have to work with experts to like figure this stuff out. And then, you also have to work with experts to figure out how to package it in a way that like normal people can understand, right? Because, it's going to be very unusual that you'll have an epidemiologist on your jury or a toxicologist on your jury or something like that. So yeah, that's kind of how I would address that specifically with respect to Roundup.
And from the defense perspective, I'm also a trial lawyer, and I've also worked on the Roundup cases. I think that we need to be careful. Just generally, when we're talking about risk factors, you do have to look at the studies. You do have to talk to experts, because risk factors are not typically causative. There's not an equivalence between a risk factor and causation itself. We're talking about an increased correlation, and an increased risk in something. But that's why you have to make sure you know what the expert is talking about when they're talking about these risk factors. And I wouldn't blanket say that there's risk factors that are necessarily irrelevant across the board for anything. It's case dependent, because there are risk factors that can be contributive to conditions which are then relevant. So it is case dependent, it is case specific, but we should be careful with terminology including surrounding the risk factors.
I'm so sorry.
I was just saying thank you.
Oh. I just wanted to add one thing, that this is kind of precisely what I was getting at with the general versus specific causation. It is not inconsistent to conclude that X product causes Y condition, but that here, X product did not cause Y condition in this plaintiff. You can find one without finding the other, and that is, from a defense perspective, why we put a lot of emphasis on looking at the whole universe of everything, because, I mean, personally, my own opinion, I think all of that is extremely relevant and something that you would need to consider, and it's why when we have mass litigation for drugs and medical devices, we are doing MDLs where we're looking at individual plaintiffs and we're not doing it class action style, because every person is different, every patient has different effects, and that's why it's important to do those. You have general causation, you have specific causation, they're different analyses.
Thank you.
My sense from the bench is going to be that the methodology should be the same across the cases, but you're going to have different science, you're going to have different plaintiffs, you're going to have different experts. As long as we're applying our own judicial methodology consistently, we should be serving both sides of the V. Ma'am?
Thank you. Mr. Finch put up a slide with a lot of the public health agencies. And post-COVID, clearly there is a diminished trust among the American people, including judges, of what public health agencies are saying. So do you expect, and I'd be interested both from the defense and the plaintiff side, do you expect there to be more action under Rule 702 to challenge what may have been, quote, well-established 10 years ago, may be ripe for further review now?
Okay, so that particular slide, it's not just public health agencies, it's things like Doctors Group, like the British Thoracic Society. It's those public health statements are based on, asbestos is one of the, other than cigarettes, asbestos has been studied more than any other chemical in the world. There are literally hundreds and hundreds of epidemiology studies, hundreds and hundreds of mechanistic studies, hundreds and hundreds of medical journal peer-reviewed articles that support these principles where the IARC says asbestos causes mesothelioma, or the EPA says that there's no safe level of exposure to asbestos. I wouldn't just rely on that slide in a Daubert hearing or in front of a jury. The last jury trial I tried was an asbestos case in Newport News. We won the case. We had a Daubert hearing 2 months before on those issues. But I had my doctor not just talk about all those scientific agencies, but he showed them published medical studies that have been around since the 60s where one day of asbestos exposure caused somebody's mesothelioma 50 years later. So it's a combination of, yes, juries don't trust public health agencies as much as they did before, but public health agencies, they still, I think, have some, they're relevant to a jury, they're relevant to Daubert challenge, and what I say is something like, don't just take the word of the public health agencies, look at all this stuff behind it. But if you ever voted in a presidential election since 1972, the United States government, through NIOSH and OSHA and the EPA, has said that asbestos causes mesothelioma and there's no safe level of exposure to it. So whether you support Donald Trump or whether you support Barack Obama, if you voted for either of those gentlemen, the EPA that he was ahead of said this is bad stuff. So that's how I use the public health stuff.
I think there is a general mistrust, and it has been increasing, and that really underscores why it's so important for the judges to fulfill their gatekeeping duty. You need to keep junk science out of the courtroom because Otherwise, the jury is going to be impacted by that. And it's really on the responsibility of the judge.
We've got time for one more question.
Oh,
Please.
so I just wanted to ask on behalf of the appellate judges in the room, what have you seen that's problematic from the appeals courts as to both perspectives in evaluating the application of Rule 702?
Emily, do you want to take that first? I'm sorry, I cut you off.
No, sure. I think sometimes there's a bit of a, tendency that isn't always positive to sort of suggest that both sides have good arguments. I think sometimes that's true. I think sometimes, though, it's not true. And I think from, both district court and appellate courts, I think are sometimes, inclined to think that it's unfair or that it's inappropriate to sort of strike, one side's experts but not the other. And, I guess the only thing, too, that I'll add with respect to regulatory agencies is that, from my perspective, I think some of the more recent events have revealed what I think some people have kind of, suspected has been going on for a while, which is that regulatory agencies are in a certain sense political, and that a lot of the data and information that they analyze, particularly in the context of product approvals, or even just, over-the-counter medications or things like that, are industry-generated data. So, there is a certain, bias that leans towards approval. And if anyone's interested, there's a woman that works at the University of Texas. She's a professor. Her name is Wendy Wagner. She does a lot of really interesting work with respect to discussions about how regulatory agencies aren't really doing science. They're not really doing the kind of thing that I think that jurors think, and that even sort of, judges and lawyers think they're doing. They're not in there with, lab coats and test tubes. They're evaluating the data in front of them, and a lot of times the data in front of them is greatly slanted in favor of the applicant or the manufacturer.
That's why I think it's important to rely on medical and scientific organizations that aren't regulatory. IARC is doesn't regulate cancer, it studies the causes of cancer. The British Thoracic Society doesn't regulate lung disease, it studies the causes of it. And as to your point about appellate courts, at the end of the day, whether you call it Daubert or whether you call it Rule 702, I think the thrust of Rule 702 is to liberalize the old Fry rule, which was that something had to be generally accepted before it got to a jury. And that's what that's what Daubert was about, and that's what 702, which attempted to codify in an evidence rule what Daubert was talking about. And so from the perspective of an appellate judge reviewing a district court's decision on the admissibility of evidence, at the end of the day, it's an abuse of discretion standard, and the trial judge has probably put in a lot of time that she, was looking at studies, looking at the experts, and made a reasoned decision. So if it's, if it's a close call, again, I would probably err on letting the jury decide it as opposed to, if the judge says it's admissible, it's an abuse of discretion standard, to go behind that is, I think, somewhat inconsistent with the Seventh Amendment.
And I would disagree with
Kelly, I'm going to give you our last word.
There's a recent decision that out of the Sixth Circuit, it's Hill versus Medical Device Business Services, Inc. And the takeaway from this decision kind of epitomizes what I think the defendants are seeing and what the defendants would like to see. Hill reached the correct conclusion, but still kind of deferred back to this language of the court having considerable discretion. From a defense perspective and from, I believe, a strict interpretation of the language of Rule 702, that is not true. It's not you may not, it's you must not admit if these things are met. And if you are asking from a defense perspective what we would like to see more of in appellate decisions, I think it is a recognition of the shift post-amendment to 702. And obviously, some of my co-panelists will disagree on how significant it is, but depending on which circuit you're practicing in, there have been positions taken that flow from the Daubert line of cases that are inconsistent with the amendments to Rule 702, and I think it is helpful for the defense side What we would like to see from that perspective is an acknowledgement of that shift, and perhaps that prior decisions under the former framework do not reflect what the new language of Rule 702 says.
I'll tell you, we've had a robust discussion. Will you please join me in thanking our panelists for their time?